Hey there, Scott Shoemaker here. I am an estate planning attorney in Cedar Rapids, Iowa, and I had an interesting situation happen just the other day. I had three children come into my office with a very interesting question, and that is their mother had recently passed away, and they brought in a copy of the will. And while their parents, mother and father, were still married and father was still living, they had been estranged but not divorced for a number of years, so living separately and all of that. Mom had written a note in her will saying that she wanted the children to inherit all of the assets and dad not to take anything. And so they asked me, is that something that can happen? Can a spouse completely disinherit their surviving spouse? And actually the answer is no. Under the laws of the state of Iowa, a legally married couple cannot disinherit their surviving spouse. That is, the spouse cannot prevent their married partner from taking any part of their estate without the agreement of the surviving spouse. So typically, a surviving spouse has three options. They can willfully disclaim any inheritance under the estate if they want to do that. And there's many reasons why they might do that, one of which is the fact that they have been separated for some time. A second option is they can take whatever is designated to them under the will. And in a lot of cases, the spouse takes everything under the will, or almost everything under the will, with a few exceptions, but that's not universally true. The third thing is they can take the surviving spouse's elective share. So this is typically a larger portion of the estate than they would be entitled to under the language of the will. But basically, the short answer is no. It is not possible for a spouse to completely cut their surviving spouse out of their estate without the consent of the surviving spouse. Anyway, Scott Shoemaker here, and I hope you have a great day. Thanks so much.